Well, thank you so much for being here this afternoon. Thank you, Kathleen. Thank you, Anita. We're thrilled to have you here and so looking forward to this conversation and to learning more about estate planning. So, with that, I'm Rachel Kissick. I'm the Director of Development at Pittsburgh Opera, and I'd love to introduce you to my colleague, Anita Sammartino, who manages our Planned Gift Society called the Monteverdi Society. Anita, welcome.
Thank you. And it's wonderful to have everyone on board and to know about the Monteverdi Society, which is a wonderful legacy society for Pittsburgh Opera. I'm so grateful to Kathleen Schneider for doing this presentation. Kathleen has a general law practice in Regent Square neighborhood of Pittsburgh. She concentrates on taxation, estate planning, administration, collaborative family law, adoption, LGBT issues, real estate, and small business startups. Interestingly, Kathleen is an attorney and a CPA, a wonderful combination, especially when you're dealing with legacy gifts or estate planning. Before entering private practice, Ms. Schneider was employed as a tax counsel by Mellon Bank Corporation, by Deloitte Touche as a tax consultant, and by the Federal Reserve Bank in various capacities. Ms. Schneider earned her BSBA degree from Duquesne University in 1981, and her Juris Doctor degree from Duquesne School of Law in 1986. She received her CPA license in 1985. She has served as adjunct professor in Duquesne University's Graduate School of Business, Master's in Taxation program, and also in Robert Boris University's MST program. She's a frequent speaker on taxation and estate planning, and we are ever so grateful to have her here today. Thank you, Kathleen.
It's my pleasure, and welcome everyone. I hope that you have stayed safe and warm during this crazy cold snap that Pittsburgh's had. And there's light at the end of the tunnel, although I hear more snow is predicted. So, curl up with a cup of hot cocoa and take a look at this presentation at your leisure, and talk to the folks at the Pittsburgh Opera if you have questions. This is a good topic, and I'm happy to share with you my knowledge over the last 40 years of doing estate planning for folks. I have lost count of how many wills and estate plans I've done. I know it's possibly more than 1,500. It could be even more than 2,000. I do estate planning for folks who just require simple wills, and I do estate planning for folks who require more complicated situations. And so one size does not fit all when it comes to doing estate planning. And I think that that's important. Many people avoid it thinking that it has to be complicated, but it doesn't. And so I would encourage, if you haven't already started this process, it's an excellent thing. You are helping your family. If you do estate planning, you are providing a structure for them at not only during your lifetime, but also then at the time of your death. You're providing structure for the folks that you've put in charge. And that is very, very helpful to them. And they will know your wishes. It's their job to carry out those wishes. If you're not able to do that. And this is regardless of how much wealth or income that you've accumulated over the years. So I want to stress that and married people need it, and single people need it. And there's a misconception that if you are a married person and you die without a will, that your spouse will automatically inherit everything. And this is a point that I make frequently. The Pennsylvania law says that if you are single, then your estate will be distributed to your parents if they are still living. And This would be true even if one of those parents has been an absolute absentee parent. So even if you've had no ties with that parent would still be entitled to half. Now, if you have children and you're single, then your children will automatically inherit. If you are married and you have children and you've died without a will, then your spouse would inherit half and your children would inherit half. And quite frankly, your spouse may not be happy about that, to know that they're sharing some assets with the kids, because that wasn't the expectation. So it's important, if you're married, to have wills, because unless your goal is that your children inherit half, uh, you may want your spouse to inherit all of it, and only a will can guarantee that that will happen. If by chance you have died without a will and you have children and you're still married, the only way that your spouse is going to end up receiving all of those assets is if the children renounce their right to inherit. And I do want to mention that. And that doesn't always happen. You want to believe your kids are going to do the right thing, and in most cases they do, but in some cases they won't. So again, very important for everybody to have a will. Powers of attorney also are really important documents. They control who has the right to make financial decisions for you in a financial power of attorney, and also a medical power of attorney as well, who has the right to make medical decisions. So we'll touch on that as well. A good estate plan process will involve a discussion of what your goals are. And goals can include many, many facets. Do you want your children to inherit? When do you want them to inherit? Do you want your spouse to have total control over the assets that he or she may be receiving? Or do you want to have more control from the grave, as they say, and maybe put those funds into a trust? All of that, important questions that need to be addressed. There's also some discussion necessary about exactly what's covered by the will. And this is looking at, if it's not covered by the will, well, what's going to control the disposition of that asset? And it's typically a beneficiary designation, right? It could also be a joint ownership situation. So a joint account, for example, a bank account, will go to the survivor of that bank account, the surviving owner of that bank account. If there's two names on an account, that's Pennsylvania law. But if there's a beneficiary, like in a life insurance plan or a retirement plan, a 401k plan, that beneficiary designation will control. So it's important to understand exactly what assets are covered under the will. And if it's covered under the will, there's a process called the probate process. And probate has become a dirty word. And so I want to talk about that a little bit and why it's not always a dirty word. I do want to touch on trusts, and they come in many, many different flavors. And trusts are amazing things. They're very flexible. They can do practically anything you want. There's some tax advantages sometimes, not always. I have many folks who come to me. They've gone to some seminar where the financial planner and an attorney are speaking to a senior citizen luncheon, for example, group, and they're out there selling trusts. And so they're going to convince you that you need a trust because you want to avoid probate. I'm going to say that in some cases, the cost of preparing that trust is going to exceed the amount of probate fees that you're going to save. So it may not necessarily be a good idea for everybody. I also want to touch on Medicaid issues. And Medicaid is the program that pays for skilled nursing home care, possibly some other medical expenses when you've run out of money. And you would be required to exhaust all of your own resources first. So I want to talk about that a little bit and how Social Security may play into that. But we will be touching on that time permitting. But it's an absolute important part of estate planning. And when I do estate planning for folks, and so if you were to approach an attorney and you wanted them to do some estate planning for you, they should be giving you some homework. And we'll talk about that a little bit. So everybody needs a will. Everybody needs a financial power of attorney. And everybody needs a medical power of attorney in a living will. And again, this is regardless of the amount of assets you have or how complicated your affairs are. The last will and testament does indicate who you want to inherit, but it also provides guidance as to, for wills that I draft, I ask you what your funeral wishes are, for example. I ask if you want to be cremated or buried. Funeral directors these days are looking for some independent verification, especially if a cremation is involved. And I will tell you that I'd say at least 95% of my clients are choosing cremation, interestingly enough. Some of them want a viewing beforehand, some of them don't. The cost, if you want a viewing, the cost skyrockets because of Pennsylvania laws requiring embalming, things like that. But that last will and testament is a very valuable tool, and it provides guidance to your family, to your executor, whoever's handling your estate. And make sure your family knows what your wishes are about these items, by the way. If you've had prepaid arrangements, make sure your family knows about them as well and what funeral home you've used to make those arrangements. If a client has already made those arrangements, when I draft a will, I include that information and indicate where those prepaid arrangements are. So it's invaluable information for your survivors, and they will thank you for being so thorough. The last will and testament also names the executor of the estate, and that's the person who steps into your shoes. So that person's duties include filing the last tax returns, getting the house sold, distributing other assets in accordance with the provisions in the will, gathering all of the assets, making sure that they're familiar and are aware of where all those assets are. Generally, an executor will hire an attorney, but it's not necessary all the time. The executor also makes sure that in addition to the income tax return that you would have owed for your last year of life, that the Pennsylvania inheritance tax return is filed. And if it's applicable, that the federal estate tax return is filed. And there's two different kinds of taxes involved there: income taxes and estate or inheritance taxes. And both of those apply. Pennsylvania generally does not have any minimum inheritance taxes due at 9 months after death, and you can extend that a little bit and file the return. Medical bills take a long time to come in, so sometimes you need an extension for the inheritance tax. I don't spend a lot of time in this presentation talking about inheritance tax, except to identify where some savings could be. But it's important to indicate in your will whether you want your estate to pay those taxes from the probate assets, or do you want each beneficiary to bear that burden? And again, I identify that in the will. Sometimes it's just not practical to have the estate pay those taxes if there are not going to be a lot of probate assets at a large 401k plan, for example, with a beneficiary. then it makes more sense to shift the burden for those taxes over to the beneficiaries who are going to have that liquidity as opposed to the estate. And, I serve, I'm on the listserv for the Pennsylvania Bar Association estate group. And attorneys complain about this all the time, that whichever attorney drafted some particular will that they're working with now for the state, that the attorney clearly didn't do their homework in terms of trying to figure out if there was going to be enough money in the estate to pay the tax or not. So, and forgive me, my grandfather clock is going off. I don't know if you can hear that or not. And I've talked already about the intestacy laws that apply. So if you died without a will, I've talked about who will inherit. If you've become incompetent and you have not designated anybody under a power of attorney, that is going to cause your family a little bit of work, and it's going to cost them a couple $1,000s to go to court to get named as a guardian for you. And the cost of preparing a power of attorney is very small compared to what the cost of going to court and getting a guardianship is. I can't stress this enough. Powers of attorney are during your lifetime, and they don't apply after death. The will takes over at the time of your death. But the financial power of attorney and the medical power of attorney are integral to a good estate plan. And that financial power of attorney is necessary because, quite frankly, banks have become very vigilant these days in enforcing the rules about who has access to information. And it's because they're afraid of the liability. So in the old days, a spouse could simply walk into a bank, do the business for their spouse, deposit a check, withdraw money, and banks would not blink an eye. I mean, there was no question asked. But in this day and age, banks will ask to see the power of attorney. They will typically pass that power of attorney by their own legal department to make sure that that person who's presenting that power of attorney has the legitimate right to act. And only then will that person have the power to make any decisions, withdraw money, possibly deal with retirement plans, banks. If the house needs to be sold, certainly no house is going to get sold without a recorded power of attorney. So powers of attorney are very, very important during lifetime. And you can see up above on this slide, I talk about durable versus springing, and I want to mention that on the financial power. What does that mean? A durable power is effective immediately. Even if you are competent, you are naming someone else to be able to act for you as well as yourself. And this is typically done in intact marriages of some duration, right? So if you've been married a long time and you trust your spouse, then you may want a durable power, meaning that even if you are absolutely competent, that somebody else also has the right to act for you. And this is especially helpful for signing a tax return, for example, or doing the banking. Even if, one of you may be at work, the other one is not working outside the home or not working at all, except doing household duties, which that's running a small corporation, in my opinion. So, spouses who stay at home and take care of the household affairs, I think are underrated. But if that's the person who can have the time to do the running around and everything, the phone calls, everything they need, that durable power of attorney will come in very handy. Now, the other kind of financial power is what's called a springing power. And a springing power only comes into play if you are deemed to be incompetent. not able to act for yourself. Now, the legal threshold for legal incompetency is different than other thresholds beyond the scope of this presentation, certainly, and it can get very complicated. When I draft a springing power of attorney, I put a requirement in that 2 doctors, treating doctors, certify that you are not able to act on your own. Okay. And I do that because clearly this person has some concerns, does not want to give up that control easily. And so 2 treating physicians have to sign off that you're not able to handle your own affairs. That could cause delay because there may have to be some determination of incompetency as determined by these 2 treating physicians. And it's unlikely that you're going to get collusion between 2 physicians, even if somebody in the family knows 1 doctor that would sign off, it's unlikely that 2 doctors are going to collude. So, very important question. I treat that question very seriously. I spend a lot of time with my clients talking about it. And many people haven't even thought about that prior to filling out my questionnaire. So, and even after they fill out the questionnaire, we still talk about it at the meeting. So, and I encourage you when you're drafting your documents that you seriously consider that question. There's no one right answer. Sometimes the answer is durable for the spouse, but maybe springing for the kids or springing for the second person who's in line if you don't have children, or even if you do, that second person in line, you may not want that person to have immediate power, but you may want your spouse to have power. So there's variations on a theme there. And I should mention, by the way, that there is going to be time, hopefully, for some questions and answers. The question in a good estate plan should center around who do you want to be your person who's going to be your agent of your power of attorney? Who is going to be your agent to make decisions for your medical decisions? I should say that the medical power of attorney that I draft, and I think most lawyers are drafting them this way these days, I draft a durable power for the medical power because I want no delay for my clients. So if a decision needs to be made, I don't want there to be any determination that that person is incompetent before the agent could act. You have a built-in protection there because under the rules that doctors operate under, they need informed consent. And if you are competent and able to make that decision to protect themselves and their malpractice barrier, they're going to get you to sign off on that treatment or whatever it is. So you have a built-in protection plan that you don't necessarily have in a financial power. And no doctor in their right mind is going to see you laying in that hospital bed, breeze right past you and talk to your spouse and ignore you in the bed. So if decisions have to be made and you're able to make them, that doctor is going to be talking to you about those decisions. So medical power, I always draft a durable power. So very important decisions. Who are going to be your agents? Who are going to be your executors? Choose people who file their own tax returns on time. Choose people who don't have 10 years worth of papers stacked up, behind the couch in the living room. That handle their own affairs, pay their bills on time. If they have financial issues, bankruptcies, or gambling problems, and gambling, I will tell you, has become a major issue in families. Online, on-phone gambling is becoming more and more of a problem. It's way too easy to do. I've had 3 clients in the last year and a half come into my office, all of whom bet more than, wait for it, $1 million on their phones. In one case, it was $2 million. And it's addictive. They can't stop. And even if they remove the app from their phone, it somehow magically reappears again. The software is addictive. So be very careful if you notice changes of behavior, if you've named somebody to be in charge and you notice changes in their behavior, or you become aware of financial issues, it very well could be due to gambling. And so I just be vigilant about that. We've talked about who you should name as beneficiaries. Sometimes it's your spouse first, and then your children second if you have children. You can include the charities or friends or other family members in this group as well. You can make unequal distributions among these people. You don't have to automatically give every child the same amount. Some children may have taken good care of you during your lifetime and you want to reward them with a greater percentage. There's nothing wrong with that. If you want to not include a child in the will, that is certainly your right to do so. You can disinherit your spouse if you like. A spouse does have the right to elect against the will, and they would be entitled to some portion of your estate if they're successful. And that's a statutory right. So even if you disinherited them, it's possible that they will still inherit some, but they may not inherit as much. And the reason for that is I don't want to get into the details, but there's some assets get added back into the estate when they're looking at the overall picture. So you want to be careful about that. I encourage you, as part of this process, to examine who you have named as beneficiaries of the assets that are passing outside the will. And you can see that I list called non-probate assets: life insurance, IRAs, pensions, 401k or 403b retirement plans, investment accounts. Some investment accounts have beneficiaries. CDs usually have a beneficiary. If you haven't done so, I encourage you to go back to all of these folks and double check your beneficiary designations. And you may find that you've forgotten over the years to make changes. In some cases, people who have been married 25 years still have their mother named as a beneficiary, and they totally forgot. So it's not like they were trying to disinherit their mother, but they just totally forgot to make that change over to their spouse. Conventional wisdom sometimes says you don't push assets up to your parental level, that instead you're trying to keep it either at your level or push it down into your children's levels. Because why? Because it's possible, likely, that inheritance taxes will be assessed on the way up, and then out of the parents' estate, if they die having those assets are going to be taxed again on the way back down. So for those reasons especially, it's not always a good idea to have parents inherit. Now, Medicaid does come into play because Medicaid is asset-based. So if you are pushing assets up to a parental level, and it's likely that your parents are going to run out of funds otherwise, you may have simply made a donation to the state of Pennsylvania, for example, by doing that, because those assets that your parents own will be spent for their care. And so you've just helped delay the time under which they would be otherwise eligible for Medicaid. And I hope I've stated that in a way that is clear. So you may have not intended to do that, but it's very important to examine your beneficiary designations. Another important question in an estate plan is, when do you want your beneficiaries to receive these funds? Do you want them to inherit right away? Or would you rather that there be a delay in getting them, maybe a staggered approach where, and I think of children when I hear this, Um, you may not want your children to inherit all of the money at age 18, for example, or even age 21. I have a psychiatrist client when we were talking about this issue with her. She had children, and she looked at me and she said, well, you know, the frontal lobe of your brain doesn't fully develop until age 25, and sometimes even later. So, do you want someone whose frontal lobe isn't fully developed inheriting a lot of money? You may not. So, there are ways that you can deal with this issue. And uh, the most efficient way is probably to create a trust. And I'm going to talk about the kinds of trust you can create, but trust would govern when those funds are going to be delivered to that beneficiary on a delayed basis. Um, you may want these funds contingent on a certain event. Um, uh, for example, graduation from college. That could be a problem if this child is not college material, or has chosen not to go to college, but maybe went to a VOCHEC school, or decided to do neither and just, you know, go out and start working outside of high school, or they've started college but they haven't finished it. So I'm careful about putting contingencies in wills, because think of the alternatives and how all of that can play out. But it's an important question. Some folks simply are not able to handle their own affairs as early as others, and so don't lose sight of that. And um, the timing of those distributions are important. Sometimes I may draft it based on the client's wishes to have it staggered in thirds. Maybe at the age of 25, they get a third, and then at the age of 30, they get another third, and then at the age of 35, they get the final remainder. It can be, depending on the amount of wealth, it could be delayed and doesn't start until 30, 35, and 40. Um, the the important question, or the important thing for you to know, is even though they're not entitled to the funds outright until whatever age you've decided, the trustee of that trust, the person in charge of those funds after you've died, um, or even during your lifetime, if you've created a trust during your lifetime, the trustee always has the ability, the power to distribute money for college, medical bills, buy a house, pay for a wedding, a down payment on a home, pay for a gap year, buy a car so they can get back and forth to school. The trustee has great discretion. And so it's not as if you're saying to the child or to a spouse that you're never going to get your hands on that money. You're just saying up until this age, you don't have the absolute right to demand that money. Okay. So um, the whoops, sorry. I'm so sorry. I we go. Um, Common issues. Should you avoid probate? That dirty word. Everybody's talking about probate. Um, I had one woman come to me. She had attended one of the senior luncheons. She was the mother of a dear friend of mine. She trusted me implicitly. She came to me and said, I want to trust. And she, quite honestly, didn't have anywhere near the amount of funds that would warrant a trust, and under $100,000. And I looked at her assets and the nature of those assets and how we could structure this, because she wanted to avoid probate. And so I was giving her ideas as to how we could avoid probate without the expense of creating a trust. And do you know, she went to another lawyer. because I told her I just didn't think a trust was necessary. She went to another lawyer, and that lawyer was all too happy to draft a trust for her and charged her $3,000 for the privilege. And again, remember, less than $100,000 in assets. And in at the time of her death, my friend brought her estate to me, and in fact, that lawyer had charged her $3,000, but they hadn't transferred title to any of the assets into the trust. So all of that work was wasted, and she still needed probate. And invariably, probate is going to be required in almost all cases anyway, due to one asset or another. So avoiding probate in Pennsylvania isn't as big of a deal as it is in some other states. Probate fees in Pennsylvania are very, very low. And I'll give you an example. I just looked at this number last week. So a house that was worth $400,000 was going to cost a mere $270 in probate fees. Okay. And the cost of drafting a trust would have far exceeded that. And so the use of a trust in that case maybe would have saved the $270 probate fee, but it would have cost far more. And remember, you're paying out those legal fees to draft that trust today when you could have put that money in the bank, earned some money on those funds, and it would have compounded over a series of years. So all probate means is that the court takes charge of passing title to the asset. Okay. So when you've died, the executor takes the will downtown, and we can swear you in remotely now, by the way. You don't have to actually traipse downtown, pay parking, and present yourself in person at the desk. You can actually do that remotely. But the will gets filed downtown, and that gives the court jurisdiction to oversee the passage of title to the assets. And so the court sort of supervises that all the bills are paid, all of the expenses are paid, the debts are paid, and that the right beneficiaries get the asset. That's all that probate really means. There are some probate fees that are charged by the court. Like I said, on a $400,000 asset, $270 for the probate fees. If you're using an attorney, there will be some attorney's fees involved. How do you avoid probate? You either name that asset in joint name so it passes automatically. You name a beneficiary on an asset, such as a retirement plan or an investment account, if you don't want to make it a joint investment account right away. Those are two excellent ways to avoid probate without the expense of creating a trust. But if you've created that trust, you will avoid probate as long as you've transferred title to all of your assets or whatever assets you've decided to put into that trust. And again, we're going to talk about the kinds of trust, but by putting it into a trust, it doesn't go through the probate process. Just like if you've named a beneficiary, it doesn't go through the probate process. If you've named a joint owner, it doesn't go through the probate process. So there are other ways to avoid probate besides the creation of a trust. In some cases, avoiding probate may be a good idea. It does not save inheritance tax. And almost every estate in Pennsylvania is going to be subject to Pennsylvania inheritance tax. Estates of $15 million or more will be subject to federal estate taxes. So if you do not have assets worth $15 million, you won't have a federal estate tax issue. And for a married couple, that's double, by the way, that's 30 million. So if you don't have assets worth that much, you're not going to have any federal estate taxes anyway. But almost everybody in Pennsylvania is going to have some Pennsylvania inheritance tax. Putting that money into a trust is not going to save one dime of inheritance taxes. If you created a joint asset, you will save half of that Pennsylvania inheritance tax because you've created a joint ownership. So only half of that asset is going to get taxed to death. That's an important consideration. There may be reasons why you don't want to create a joint asset. If that person, let's say you put your child on some bank account and that person ends up getting into a car accident, kills someone, and has liability, is determined to be on the hook for damages as a result of that unfortunate event. It's possible that half of that account will be considered eligible for a settlement for a lien that would be placed for any liability that's determined. It gets messy in a divorce. If half of that asset belongs to your child and that child gets divorced, then the gift itself of half of that account wouldn't necessarily be a marital asset, but any accumulation of value in that account would be. And that's fair game for the spouse who may not necessarily be on good terms with your child at this point. That's fair game for that other spouse to claim as a marital asset. So yes, you avoid probate with the joint asset, but there are risks involved. There's also the issue of giving money away, and this is the last slide for Medicaid issues. Giving money away isn't always necessarily the best thing to do, especially later in life. I've been talking about trusts. There are various kinds of trusts. You can put money into a trust, and that means you actually have someone draft a document called a trust agreement. You can have it be a revocable trust, meaning that you can put the money in and then you can take the money out. You can change your mind. And sometimes that does happen. In some states, and I'll use California as an example, it's malpractice for an attorney doing an estate plan for a married couple. It's malpractice not to create a trust because of the way that their estate tax laws are written. Estates of any significant wealth are taxed differently if they're in trust versus not in trust. So in Pennsylvania, again, revocable trusts aren't as common as they are in other states. And the cost of preparing that revocable trust may not be worth it, depending on what your goal is. If your goal is to save inheritance tax, you're not going to meet that goal by having a trust. If your goal is to avoid dreaded probate, you will avoid probate if you transferred all the assets into the name of the trust. And that's no mean feat, by the way, right? There's a lot of work involved in retitling all of your assets into the name of the trust. And so there's a little bit of work there after that trust is created. They do not save inheritance taxes, but they do eliminate probate. So revocable trusts can be very useful. Generally, even if you've put that money into that revocable trust, you, as the person who's created that trust, are still going to have to pay all of the income taxes on any interest or dividends that those assets are earning. So you're not saving income tax either. You're going to get taxed as if you still own the asset outright. Why is that? Because it's revocable. You can change your mind. You haven't transferred the benefits and burdens of ownership out from under you to someone else. So therefore, you don't save income tax, you don't save inheritance tax. There is such a thing called an irrevocable trust, and it is irrevocable. You can't change your mind. Once you put an asset in the name of that trust, it's there and it cannot be revoked, that's a pretty serious thing to do. Generally, these trusts are not used except for folks that have significant wealth, quite frankly, or they're trying to do advanced Medicaid planning. And if the thinking is that if you get all of these assets out of your name into the name of this irrevocable trust, then at the time that you have the need to go into a skilled nursing facility, that you've protected those funds for your family, and that the assets will not be available for your care. There's a 5-year look back rule for Medicaid. And that is a long way to look forward. It's hard to predict the future for 5 years. The problem with doing that also is if you've done that, then it's hard if you have gone into a skilled nursing facility, you've slipped and fallen, you are not able now to take care of yourself, and you don't have a family member or a friend who's going to take you in, and that's a big undertaking. Caregivers wear out quickly. Where is the money going to come from to keep you in that nursing home? If you've exhausted all of your assets, where's the money going to come from? Because the nursing home can kick you out. If you've made these transfers within 5 years of running out of money, if you've, I'll use the words, intentionally bankrupted yourself. And I don't mean that in a derogatory way. I mean, you should take advantage of anything that you can do to save family wealth. However, if you have intentionally bankrupted yourself with that goal in mind, and then you unexpectedly go into a nursing home, nursing homes cost on average in Western Pennsylvania $15,000 to $16,000 a month for skilled nursing. $15,000 to $16,000 a month. So that's under $200,000 a year. Those costs keep going up every year. Most people don't have $200,000 a year times 5 to pay for their skilled nursing care on their own. If they transferred assets to somebody in the family or into this irrevocable trust, that's a problem. And so I just urge you to think carefully before creating this irrevocable trust. That's also true for transferring assets out of your name just generally. There's also a kind of trust called a testamentary trust that's created under your will. And the advantage of doing it in your will is that you're not paying for the creation of this big fancy trust in a separate document today. There's some paragraphs that would be included in your will when it's being drafted that would deal with who's going to be covered under this trust. Is it age dependent? Who's going to be the trustee? All of the big items are covered in your will, but you haven't paid somebody to create this trust before you've died. And it will only get created, this trust, if it's necessary. So if all of the kids have aged out and they're all 45, 50, 70 years old at the time of your death, then no trust may even be necessary, and you didn't pay all that money unnecessarily to create a separate trust on your own. So a testamentary trust is, in my opinion, something that should be considered. It's not good for everyone. It's not necessary for everyone. It's especially useful for grandchildren, for example. But the bottom line is that it's not overkill. You haven't created this trust unnecessarily and paid a lot of money outside the will to do that. Special needs trusts are trusts that are created to benefit disabled folks. And the goal is to put the money in trust for this disabled person, but you do it in such a way that the government benefits that this disabled person are receiving will not be interfered with. because if they lose those governmental benefits, it's usually having to do with medications or other housing benefits that they may be entitled to. The funds in the special needs trust will not be considered to be eligible to be used for those kinds of living expenses. And so therefore their governmental benefits are protected and they would still qualify to get them. And there are certain rules and certain language that has to be used in order to guarantee this result. It's a complicated set of drafting rules, but very doable and very useful for disabled folks to continue to get government benefits and protect those funds that are there. There's also charitable trusts, and I know that we're a little short on time. I would urge you, if you have wealth that you are interested in transferring to a charity, that you solicit the advice of a good financial planner. Good financial advisors are always very, very useful, but also a lawyer who's experienced in these matters. There are income tax ramifications of doing these kinds of trusts. Sometimes the charitable lead trust is where the charity gets the benefit of the money right away, and you, as the grantor of this trust, then will benefit later. Okay, but the charity gets funds immediately, you get the funds later. There are various flavors of these kinds of trusts, complicated income tax rules, complicated federal estate tax rules, but very useful if you want to reduce the size of your estate. And with a $15 million limit under the federal estate and gift tax rules, these kinds of trusts may not be for everyone, but if you are in a position to be charitably minded and you want to give significant gifts, charitable lead trusts are very useful. The same with charitable remainder trusts. It's sort of the reverse of a charitable lead trust. So in a charitable remainder trust, the monies are given to the charity only at the appropriate time, whatever the term of the trust is. But in the meantime, you may be receiving the income during this initial period, and the charity is getting the remainder, whatever is left. There are certain rules, again, as to timing and how much. You may hear the term unit trust versus annuity trust. The same applies, by the way, to the lead trust. All terms that are important, and it has to do with, are you getting a sum certain every year versus getting a percentage of what the assets are worth? So all of that needs to be considered, but again, a very useful tool if you're charitably minded. I really do recommend that you consider those kinds of trusts, especially if you are in a position to be generous with your wealth. There's also the charitable gift annuity, and this is especially useful for folks who may not have the wherewithal or have to worry about a $15 million limit, but you want to be charitably minded. And these are very popular. And I know that the opera works with the Gift Annuity Foundation, the National Gift Annuity Foundation, with these gifts. For the opera, Anita, correct me if I'm wrong, but the minimum gift under the opera's rules is $20,000. Is that correct? I think that that's the case. And so
Yes, that's correct.
Thank you. I think that they are very useful. It gives you a fair amount of flexibility. And again, they're much easier to set up. You're not paying for the drafting of the big fancy trust. Instead, you're using the resources that are available to you through this National Charitable Gift Annuity Foundation, working with the charity of your choice. And I just do want to mention, and I'm not supposed to do this, but I will say that the opera would be happy to entertain any gifts. But I'm still not, this is not a sales pitch for the opera. But, the opera is a very worthwhile cost. And so obviously, if you're on this call, you may be so interested. Um, the charitable lead trust, the charitable remainder trust, suitable for high wealth individuals. You don't do this lightly because it's irrevocable. Once you create this document, and this is true for the charitable gift annuity as well, it's irrevocable. You don't get to change your mind. So if something catastrophic were to happen, you are not going to be able to get your hands on those funds. And very, very, very important consideration. There's also something called donor advised funds, and some people like them, some people don't. You may have heard about them. They've become more popular lately. This is where you, as the taxpayer, create a fund with a financial advisor, usually, and you create this fund, you put money into this fund, and then you get a deduction right away for whatever you've put into the donor advised fund. Now, there are limits as to how much the charitable deduction you will be entitled to. And without going into a lot of detail, there are limits. You can't deduct more than generally for cash gifts of 60% of your adjusted gross income. Okay. And if you're contributing assets that are appreciated assets like capital gain assets, you are entitled to deduct only 30% of AGI. And that number can go down if we're looking at some other kinds of like a private foundation, something like that. So the donor advised fund benefit is that even if you haven't decided exactly which charity you want to give to, you can get a deduction right away simply by putting money into this donor advised fund. And then you can pull this money out as you want to fund various charities. And as long as there's money in the donor advised fund, you can continue to be generous. But this is especially useful for clients who aren't sure exactly. Sometimes it's because a husband and wife can't agree exactly on which charities they want to give to, and that happens. And sometimes they just need a little more time to agree among themselves. But also, sometimes there's a little hesitation. They don't know what the market's going to do. So they may want to create this donor advised fund, put a little bit of money in today, but then continue to put money in over their lifetime. Or they can fund it then at the time of their death through their will, and with some direction then as to what charity or charities are going to benefit. They're useful, very flexible, no cost to you to set this up. And again, a nice way to be charitably minded without going to the expense of creating those big fancy trusts that Bob was talking about earlier. It is irrevocable. You cannot get the money out, even if you need it. And I just want to let everybody know that effective now in 2026, any charitable deductions, any charitable contributions that you're making, you're going to take a haircut of 0.5% of your adjusted gross income. And only then will it get added to your itemized deductions on your tax return. And itemized deductions are those deductions like mortgage interest, state and local property taxes, income taxes, charitable contributions, extraordinary medical costs. All of those are your standard itemized deductions, right? Remember, they went away for a while. They're more popular now because state and local taxes are back, and you, in most cases, are going to be able to deduct those state and local taxes that you're paying, and that's your state income tax, your local wage tax, if you're paying any, your property taxes, all of those, for the most part, are going to be deductible. That greatly enhances your ability to itemize deductions instead of taking what's called that standard deduction. So even if you weren't itemizing last year, you may be itemizing for 2025. When I say last year, I mean the last filing season, and we're heading into the filing season for 2025. You will be able to take advantage of this for your income tax return for 2025. But for 2026, there's this 0.5% haircut. So if you're not familiar with that, take a look, do a little reading, talk to your tax preparer. Your financial advisor, I'm sure, is going to be aware of it as well. So hopefully you took advantage of that in 2025 by using a donor advised fund, perhaps before that haircut went into place. Medicaid, I've already alluded to it. Medicaid is a benefit that's a combination of federal funding and state funding. It varies from state to state, so not every state's rules are the same. Very important. What Medicaid will do is if you've gone into a skilled nursing facility, for example, and you have exhausted all of your assets, you can apply for Medicaid. The nursing home will help you because it's in their best interest to get paid from Medicaid funds. So if you own a home and you've gone into a skilled nursing home, you don't have to sell your home right away. They will give you at least 6 months or more to see if it looks like you're going to be permanently staying in this skilled nursing facility. Assisted living is not the same as skilled nursing. Assisted living is where you're more mobile. They usually provide 2 meals a day, maybe 3 meals a day. You have your own living quarters, and there are various facilities all around. They generally run $5,000 to $7,000 a month. Very different than the skilled nursing environment. And the cost of an assisted living have to be borne by you out of your own personal funds. The skilled nursing home, also the costs have to be borne by you as long as you have the money. But once you've run out of money for skilled nursing, you can apply for Medicaid. I will tell you, and I just went through this last year for a client. I was acting as a power of attorney agent for it's painful. The process of qualifying for Medicaid is painful. They want 5 years worth of bank statements. They want you to remember what you did with the funds, 3 years ago. Why did you transfer $400 out of that bank account, that checking account? Where did that money go? It's especially difficult if the person that is the subject of this whole process has no memory, and you're walking in as an agent where you don't have personal knowledge. I said to them, if I was not able to explain it, that I didn't have that personal knowledge. Therefore, I couldn't answer the question. In the end, we were successful, but we applied, and it took 1 year to get approved. And I was very responsive in giving them everything they asked for. It just, you get denied almost routinely at first, then you appeal it. In my opinion, the process is a little unreasonable, especially when it's absolutely clear that there are not any assets there for the taking. But in the old days, it used to be that wealthy people would bankrupt themselves and give away all of their assets and then stroll into the nursing home and have the state pay for their cost of care. And so then they decided to put a 1 year rule in, where a 1 year look back. So you couldn't bankrupt yourself and within a year apply for Medicaid. Well, too many people were still applying for Medicaid, and this is way back in the day. So then they created a 3 year rule. And it still seemed to allow a lot of people to do advanced planning and give away their assets to have the state pay it instead of themselves. So then they finally settled in on a 5-year rule. And the 5-year rule, I think, is accomplishing its goal. It's really hard to plan in advance 5 years. So, but at the same time, um, it can't happen. So if you are in good health and you want to do Medicaid planning, that's a good time to do it, as long as you're pretty confident that by giving your assets away, that you're not going to need what you have left. And if you do need what you have, if you need more than what you have left, and you've given it to your children, for example, I'm hoping that your children will step up to the plate and sort of help you, not by giving the money back, but by helping you pay your expenses outside of your bank account through theirs. And again, not every child will do the right thing. And so there is some risk there. And if you cannot pay the cost of your skilled nursing facility and you have violated this 5-year rule, they have every right to kick you out, and they will. Okay? And they will, because nursing homes lose money. It's very hard to make money in a nursing home environment. The rules for Medicaid differ if you're single or married. In many cases, if I have a married couple where one of them is going into a nursing home, I will, in many cases, discuss transferring the house, the names on that house, to the name of the person who is staying in the community, the person who's not going into that nursing home. And that protects that asset irrevocably. There's also an exception if you've had maybe your child living with you, taking care of you for 2 years in your home, and we've added your child's name to the deed. If you've met that 2-year requirement for the child being your caregiver, keeping you out of that skilled nursing facility for at least 2 years, that child can keep that house, and it will not be required to be liquidated under the Medicaid rules. So if you have a child who is doing a good job of taking care of you, living in the home with you, it has to be their home too. But if that's the case, you may want to consider transferring the title over into maybe a joint name with you and your child. And that child will own that jointly with rights of survivorship. That's how the deed would be prepared. And under the 2-year caregiver exception, that child can then inherit that house free and clear. No Medicaid liens will apply at the time of your death. Okay. Very important. Social Security. I think we've run out of time, Rachel. Is that true?
We are a little short on time right now, so if you can just maybe touch on this very quickly, Kathleen, and then we'll continue on. Thank you.
Yeah, absolutely. Social Security is a factor. If you are entitled to Social Security benefits and you've gone into a skilled nursing facility, for example, what happens is that the Social Security Administration will eventually start paying your benefits over to the nursing home. And you're allowed to keep $60 a month, and that will pay maybe for the cost of a cell phone or a haircut, maybe ordering a pizza into the nursing home because the food's sometimes pretty bad. But, Social Security benefits will be used to help pay for your skilled nursing facility. If you're married, you can collect under your own earnings record, and your spouse collects under their own earnings record. If your spouse dies, you are entitled to get the higher of either your Social Security under your record or the benefits that your spouse was getting, whatever is higher. But at the end of the day, you're still getting less Social Security than you were as a couple, but you at least are entitled to those survivor benefits. If you are divorced and you were married more than 10 years, you are entitled to claim under your spouse's earnings record, your ex-spouse's earnings record. Very important. And if divorce is on the horizon and you have not been married for 10 years, but you're close, try to hang on for that 10-year period because that could be very, very important later in life. Um, and if you remarry, um, it's possible that you may lose the benefits from your first spouse, although I am not a Social Security expert. So if if a remarriage is on the horizon, I would check the rules, talk to the Social Security folks. Believe it or not, they're very helpful. We have great people in the Pittsburgh offices in Social Security, and you can make an appointment and talk to them, and they'll give you the answer straight up. They don't play games. Um, I think that that's it. If there are any questions, I'm happy to entertain them. But it's been a pleasure. I hope I've helped you. I hope I've given you food for thought and important questions to ask, right? So stay warm.
Thank you so much, Kathleen. This has been a fantastic presentation, and I always love these because I learn so much, and I know that everyone else is going to be able to take away lots of good information from this. So thank you.
You're welcome.
Um, a huge thank you again to everyone who joined us today. Anita, if folks want to learn more about the charitable giving component of this through the Monteverdi Society, what do you recommend they should do? And Anita, let me see. We've got you on mute still.
Okay, here we go.
There we go. Perfect.
Yeah, if they would be in touch with you, Rachel, or with me. Now, the only issue is here, how can we put that right? We can each be
We'll add something to this.
Yeah, yeah. Okay. I think what we have to do is just add our names and contact information at Pittsburgh Opera, and therefore they can call or contact us for further information. Also, they can go to the website. So we have a plan giving page on the website if they're interested in leaving a legacy for Pittsburgh Opera.
And
Thanks.
as I understand it, Anita, based on the conversations you and I were having, if they do make a pledge uh, as part of their estate planning, if they make a pledge to the opera, they automatically become a member of that Monteverdi Society, correct?
Exactly. Not only do they become a member, they become a permanent member. So their name will always be affiliated with Pittsburgh Opera. So it's a wonderful, and there are no gifting clubs. So the amount of your legacy gift doesn't matter. I mean, there's no, so you're listed alphabetically when you're recognized. Our legacy gifts range from 1,000 to 3.5 million. So and the gift amount could be any amount. As long as you inform Pittsburgh Opera that you have left Pittsburgh Opera in your estate plans. Okay.
Well, thank you. A tremendous thank you to both of you and Kathleen. Stay warm out there. Thanks for coming.
Thank you.
Thank you.
Take care, everybody.
Bye-bye.
Thanks. Bye-bye.